have the pleasure today of doing the first of what I hope will be a series of rather unimaginatively titled Conversations with the CLA President. And today, coming from Northern Ireland and living and practicing in Belfast, I thought the first of these discussions should be with a prominent lawyer, perhaps the prominent lawyer in my jurisdiction, namely Sir Declan Morgan, the Lord Chief Justice of Northern Ireland. And I hope that after this discussion, there will be other discussions in jurisdictions around the Commonwealth with other prominent legal figures. Chief Justice, thank you very much for agreeing to make the time and have this discussion with me this morning. It's really greatly appreciated.
Brian, it was a great pleasure. I was delighted to have been asked to participate in this. I'm sure that there are many interesting discussions that you'll have in the course of doing similar work, and I'm glad to be able to make my contribution to the work that you're doing as President of the CLA, and it's a great pleasure for this jurisdiction to have you in that position.
Well, thank you very much. Of course, you're no stranger to the CLA. My first experience was in Hyderabad in, I think, 2011, and I remember you contributing there. But I think you were saying as we were preparing that you have a memory going back even earlier than Hyderabad.
Yes, I think my first Commonwealth Law Conference was, I think, 2005 in London, and then again in 2007 in Nairobi. And in both of those conferences, I attended as the person in charge of law reform in this jurisdiction. And of course, one of the interesting aspects of the work of the conference is that there are various specialist groups, as it were, who meet up on the edge of it, and CALRAS, the Commonwealth Association of Law Reform Agencies, is one of those, which of course is organised and pursued by Michael Sayers to the benefit of everybody. As somebody new to the area of law reform, I remember very well that I really had my eyes open to the different ways in which all sorts of jurisdictions with different backgrounds approached these questions. And in all of those conferences, I came away with the benefit of the thinking of people from other continents, from particularly our friends in Australia and New Zealand, who of course are very hot on law reform, as indeed are many of the other Commonwealth countries. And that's one of the things I think that I've always found about attendance at the conference, that apart from the friendships that one makes at the conference and the understanding of the circumstances of people in different areas, there's a huge amount of learning for all of us who actually attend the conference, which we can take back into our own jurisdictions.
Yes, it's that combination of friendliness and yet learning and a willingness to share experiences that I have found particularly beneficial. And some of the friendships have been, of course, very enduring. I did mention yesterday we had an executive committee meeting, and I said I was having this opportunity, and everybody on the executive committee very warmly said, oh, well, if you get the chance, say how much we've enjoyed your historical contributions, and we look forward, hopefully, to you attending our next conference.
That's very kind of you to say so, Brian. And of course, then my subsequent engagement meant that I had the opportunity to attend the Chief Justice conferences, which again took place on the edge of the General Conference. And again, there's a huge amount of learning, as well as a number of very good friendships that developed as a result of that. So for me, the Commonwealth Law Conference has always been a highlight, and I've known that it would be both enjoyable, but that it would also be a learning experience, and I hope in some way also an experience to which one can make a contribution to the benefit of the others who are there.
Some of the contributions are made formally, but often it's the informal coffee chats that you find yourself sharing a biscuit with, with a chief justice of another jurisdiction or a prominent advocate, and it's that aspect that I particularly love of the Commonwealth conferences.
Yes, no, I agree with that, and there are enormous opportunities to follow up as well when, if you get involved in a particular item or speaking on a particular item, to then have the opportunity to follow that up over a cup of tea or coffee is when you can really get into the meat of the thing, and of course it's also where you begin to form these friendships and relationships that are always so important.
Well, those, of course, are when people are together. And I suppose just moving on, our next conference that we very much hope can take place and people will be physically together is on the theme of sustainable justice and the role of the law and the lawyers. And we cast that fairly widely because you need training and young lawyers coming through and qualifying. You need an economically viable profession. And you need a judiciary that's independent and recognized and protected, all to have the justice system sustainable, as well as access to justice being available. Did you have any reflections when I shared that theme with you?
Well, I suppose the circumstances in which we find ourselves at the moment with the restrictions as a result of COVID-19 have brought into sharp relief the need to ensure that there's a justice system which is available to the community. And there has been a lot of quite swift movement in our jurisdiction in order to try to put together methodologies of ensuring that the public can continue to have confidence that the justice system is there for them and that they have access to it. It has been difficult. I think we've had to do things in a period of weeks that normally would have taken us years to achieve and get used to. But I think what it probably demonstrates is that the legal system can be flexible and can respond in fairly quick order to markedly changing circumstances. And it is something of a test for us to be able to demonstrate that whatever the circumstances, that we will ensure that we play our part in making the legal system available for the public. And I think in a way, one of the things that helps that is that from my own point of view, I have always firmly believed in the proposition that the independence of the judiciary doesn't mean the isolation of the judiciary. We don't want to work in a silo. We need to recognize that we have a part to play in ensuring that the justice system works. But there are many other players as well. The professions, obviously, are major contributors to making the system work. And there are other state agencies and those people who themselves want to ensure access to the profession and perhaps find themselves having difficulty because of financial circumstances or whatever. We need to do our bit to ensure that can be achieved. And that has been a big issue for me during my period as Chief Justice now for just over 10 years, because I think there was a perception that we were a judiciary who stepped back from engagement and collaboration and working together. But particularly over the last 10 years, since justice has been devolved in this institution in Northern Ireland, we've worked very hard to ensure that we have a collaborative system. And I participate regularly now with other colleagues from other agencies in seeking to ensure that we put our system together in an effective way, and we're doing that at the moment.
Yes, one of the I've had some regional discussions with colleagues, and one of the lessons to emerge is how everything is so interconnected that that government-supported loans, which might need to be secured to the borrower, needs a land registry to function, and that you need to have, in doing due diligence for commercial matters, you need to have up-to-date registers, and that while the courts and the access to judicial decision-making is important, all of the other transactional work that involves controllerships or probates being issued, or adoptions and the protection of children, these are all interconnected as part of the administration of justice. And I wonder, as Chief Justice, given the constraints that we very rapidly became under, how you approach prioritizing the system of court-delivered justice.
Well, I think, as I said earlier, one of the important things is to recognize that one is part of a group, that there is that collaboration and joint working is extremely important in these areas. So from my point of view, I engage with both government, the prosecution service, the police service, the Department of Justice in a formal way, but I also set up and we do that regularly, but I also set up regular contacts with the professions, because I needed to get an understanding from the professions about the areas which were hurting, if you like, both the economy and the individuals within society. And we, one of the things, for instance, we prioritized was shifting resource into probate, because it was an area which was very important in terms of getting completion for all sorts of transactions. And I think one of the things that the issues around the virus has shown us is the benefit that can be achieved from having that regular conversation and the ability to engage regularly in it. So I meet the professions now about once a week through our friend Zoom, and we discuss where the priorities need to be. And although inevitably, as a result of the present situation, it's difficult to get full staffing levels or anything like it available, we then have shifted resource into the areas where the profession think we can make progress. And I think being responsive in that way, from my point of view, has been a very important both lesson and obligation as a judicial leader, to ensure that I played my part in making that work.
Well, I think it has worked enormously successfully, if I might say so, Chief Justice, and the communication is important to the profession and to wider society as well, and that's been extremely effective. I wonder, just as almost a closing reflection, that you've mentioned our friend Zoom, and we've all been upskilled very rapidly, and indeed the old voice-only conference call seems a bit old-fashioned now, doesn't it, when you
yes.
have conversations like this? In terms of operating a trial or hearing applications, do you have any reflections on the advantages and some of the concerns about using technology for court business?
I think there are certainly advantages in relation to the use of technology. The fact that we can have this conversation in this way, and we could easily, as you know, have had the same conversation if you were in Asia or the United States or any other part of the world, really, when it comes down to it, is an indication to us that, you know, there are significant advantages out there for us. I think the experience of, when we have a system, criminal system, which depends on jury trial, and I think we're still trying to work out whether or not the technology would ever be able to help us in relation to that. I mean, people have suggested that the jury could look virtually at the witnesses giving evidence. I don't think there's a huge degree of enthusiasm for that. I think the other thing that we wonder about is whether the technology is really suitable for cases where the court has to deal with the empathy that particular clients who come into court perhaps need to ensure that they can give the best account of themselves and explain their position, and that of course arises most frequently in family work. And although initially there was a degree of enthusiasm for doing family work on a remote basis, certainly in this jurisdiction now that enthusiasm has waned somewhat, and I think there would be a concern about having unsupported participants in a family case at home on their own, having to deal with what were really very emotionally troubling aspects of their lives, and a strong feeling that if you're going to have that type of hearing or environment, that people should be there, the court should be there to support the person as well as to hear what they have to say. So I think in the round, technology is a tool. We need to use it to advantage. We need to be careful that we don't misuse it. And I think that's where we are at the moment.
Yes, sometimes you, as we are doing today, we're only seeing really us from the neck up, so to speak. But
well, I shudder to think, Brian, if you got your shorts on.
well, it's not that. I was wondering, are you drumming your fingers impatiently, saying, "I wish this was all over"? But
No.
But it's that sort of interaction between the advocate and the judge, and there's more to it than simply expressing words. There's trying to get the whole picture, which the technology doesn't quite deliver yet.
Yeah, I mean the object at the end of the day is to get it right, and the tools that we use through the courts, the adversarial system, etc., are all designed to ensure that for us we think is the best method of actually doing it. Others have a more inquisitorial system, and I'm sure in many areas the inquisitorial system has marked advantages, and we actually take a much more inquisitorial approach when we're looking at family work than we do at some other work. But there again, that's one of the many lessons that you can, areas that you can explore in conversation with colleagues when one has the advantage of attending a Commonwealth Law Conference.
Well, you see, it's just a perfect note on which to sum up, because we are very much looking forward to and have drawn together a brilliant program on paper. We're trying to fill the slots with eminent speakers. I'm not promising, but you could be on our roster of people to be approached, and given what you said at the start, I'm sure that you will be at least motivated to try and assist, and we in the CLA very much value the support and contribution from leading figures like you are, and thank you so much for sharing some thoughts this morning, and I wish you well in the rest of your days, and hopefully we will see you in person soon, but in the meantime, thank you for leading the response to the pandemic and the administration of justice in Northern Ireland, which I think has been accomplished really well. Thank you for your time this morning, Chief Justice.
Thank you very much, Brian. It's been a real pleasure.
Thank you.